This is the Law Hub podcast brought to you by Law Hub Gambia. On this podcast, we discuss critical and existing institutional frameworks, developments, and processes. Join us as we embark on this exciting journey to learn about trafficking in persons, children's rights litigation in the Gambia, women's absence at the decision-making table, barriers to women's access to justice, women land rights, and strategic litigation in the Gambia. The Law Hub podcast is proudly supported by USAID American Bar Association Initiative through its project on promoting rights and justice in the Gambia. Visit our social media platforms on Twitter, Facebook, Instagram, and YouTube to catch up on your favorite episodes. Law Hub Podcast, leveraging technology to promote legal literacy and enhance access to justice in the Gambia. Hello and welcome to the Law Hub Podcast brought to you by Law Hub Gambia. Law Hub Gambia is a legal knowledge institute that provides free and reliable online access to essential Gambian legal resources for researchers, students, policymakers, lawyers, and the general public. This year, Law Hub brings you a project titled Leveraging Technology to Promote Legal Literacy and Enhance Access to Justice, with support from USAID American Bar Association Rule of Law Initiative through their project on promoting rights and justice in the Gambia. This project is meant to create awareness of the various legal systems in the Gambia, especially with respect to access to justice, women's rights, as well as the processes of approaching the Gambian courts and the specific opportunities and challenges. The Law Hub podcast is one of the activities implemented under this project, created to discuss critical and existing legal and institutional frameworks, developments, and processes. On today's episode, we'll be discussing strategic litigation in the Gambia with focus on the challenges and opportunities that exist. And we have as our guest, Mr. Abdoulaye Fati, a legal practitioner and executive member of the Gambia Bar Association. Mr. Fati, welcome to the Law Hub podcast. Could you please introduce yourself to our viewers and give us a brief description of your academic and professional background?
Thank you very much, Ngone. I am Abdoulaye Fati. I am a private legal practitioner, the Secretary General of the Gambia Bar Association. I studied in the UK where I did my LLB, LLM, and did my bar and called to the Bar of England and Wales. I returned back to Gambia in 2015. Shortly after that, I worked as a magistrate for a year. I resigned and went into private practice. So from, I think, around March, April 2016, I've been in private practice. I work both as prosecuting counsel in civil matters, as well as defense counsel, both in criminal and civil matters.
That sounds like a very extensive experience in litigation in the Gambia. So I think I'm confident that you are the perfect guest for today's topic. Just to begin the discussion, could you please explain to us what strategic litigation means? How would you describe it to the layperson who wants to understand the concept, but also the purpose of strategic litigation?
Strategic litigation is essentially where you use the law or the legal tools or the legal process to achieve broader societal changes, particularly through policy and legislative reforms. So essentially legal, positive legal or societal social changes. The concept, particularly in America and probably in Europe, is where it is very advanced. Organizations, particularly civil society organizations or private entities, use this process or concept, or to achieve broader successes. But in Gambia, I think we are still at a very young infant stage when it comes to people exploiting what strategic litigation could achieve. And I would like to think it is probably even more relevant in our context, because there are so many things that when we strategize and exploit the courts, whether there is success or otherwise, but then you were able to probably bring to the attention of government and the policymakers some very important issues that affect certain constituencies, particularly women, and I'm sure during the course of our discussions, we will touch on some of those important issues that perhaps can be looked at, although there are challenges and difficulties as well, because this is an area that is not particularly exploited in the Gambia. Because of that, I do not think our courts are very conversant with the, but that is gradually changing.
That's slightly changing, and I believe I would be tempted to agree. But first, I would also want to know, in the Gambia, is there any foundation for strategic litigation in our jurisprudence?
Yes, there is, even though it is very limited. But I can, over the last few years, there's been some public interest. So essentially, when we talk about strategic litigation, it is where some people will refer to it as human rights lawyering or human rights litigation. Some will describe it as public interest litigation or class action lawsuit, but they all fall within the broader concept of strategic litigation. So because essentially what you're doing is to strategize, to use the legal or sometimes non-legal processes to achieve a particular. So in the Gambia, in terms of foundation, I think I am not particularly aware of, but in terms of jurisprudence, there's been some, none less than the case of Yankuba Toure, for example, which I believe there was public interest litigation, and it had really significant effects in terms of our transitional justice journey, but in terms of solidifying constitutional principles of making sure that human rights abuses and violations are investigated and where appropriate prosecuted.
Okay, but I think one thing that I think would be beneficial to our viewers, but also young lawyers who may be interested in exploring strategic litigation, is that first, do you require special training to engage in to litigate a case, to engage in public interest litigation or strategic litigation? And secondly, is there anything in our laws, or is there any constitutional or any legal provision on which you can ground a case of strategic litigation?
Okay, I do not think you particularly need a specific training, even though training will be very useful. What I mean is you have to have the tools. You have to be probably grounded in the area, because this is broad. So it could be public interest in terms of seeking to do some constitutional change or public law stuff. Or it could be public litigation or strategic litigation in relation to land, in relation to children's rights, women's rights. So I am not aware of a particular training school, but I think these are skills that you acquire over time. But I think what civil society organizations can perhaps do is to work with certain, experienced legal practitioners who have interest in this area, so that probably there's capacity building, so that civil society organizations or specific that target certain constituencies like women's rights organizations or children's organizations can begin to understand how they can exploit the legal process and the legal system, and really advance their understanding, their knowledge, their approach, so as to now exploit the opportunities presented by strategic litigation to achieve. So I can give you an example. For if you look at the last 3-4 years, we all see on social media that probably women go during childbirth, they go to hospital, and because of some inaction of a medical practitioner, I've seen an instance a couple of times we've had where women have died because somebody didn't do what they were supposed to do, or probably there wasn't enough blood. So one area, and that's an area I'm interested in, I've actually thought about it because I had an incident one time when I thought I'm going to contact the family, and it's time that we push the envelope, we push the boundaries. So perhaps this is an area where such family could be assisted by an organization that focuses on this area, go to court. So perhaps the thing here, because public interest litigation or strategic litigation sometimes, more often, sometimes it is like a group of people or an organization that has a broader societal objective. But an individual can go because the consequences of actually going to court in itself will be breaking barriers. But where there is success, for example, that may lead to change in law or policy. So, for example, in relation to this, I think it is about time where somebody takes such a matter to court for negligence. So what would have happened is, I'm not aware of any case in the Gambia, particularly in this area where if this is from the RVT, for example, or the Edward Francis Small Teaching Hospital, where you seeing that facility, the AFHT, Edward Francis Small Teaching Hospital, as well as government for negligence. I'm giving you an example. So the awareness that would raise, both for public hospitals as well as private hospitals, is that they have to be careful, that they owe a duty to these individuals, and where you haven't satisfied the threshold of meeting those obligations, then you would have breached a duty of care to that individual. And therefore, so going to court alone is also breaking the taboo that when somebody dies, we just have to accept and move on. So for women's rights organizations, for example, or children, you are now amplified, you are now given courage and platform that when some of these wrongs occur, they can be challenged in court. Whatever the outcome, I believe it would force some of these providers to better their standards in terms of providing medical care and health care to women, particularly pregnant women who come in those really desperate times, requiring immediate attention and adequate medical care. But there are several others as well that I think specific organizations can look at to really exploit, because I think there are a lot of opportunities, even though there are constraints, because our system hasn't fully come to understand this concept. And because of that, sometimes the courts may not be as accommodating as they would you would like them to be, particularly as how they will in more advanced countries, maybe in America or places like the UK.
And that point actually leads to the next question I was going to ask, which I think is very crucial. Are our courts equipped to handle cases of strategic litigation? Because as you said in your previous responses, this is not a very common thing that we see in the Gambia. We've heard of few cases, like the case of Yankuba Toure, where the Supreme Court was petitioned to interpret a provision in the Constitution on its constitutionality. So I think one, you've already answered that, is that our courts may not be well equipped to handle such cases. But also, too, in your experience in strategic litigation cases that you've been involved in the past, could you describe to us what form it looked like? How did you choose those cases? What was the outcome of those cases, and what impact has that had on our legal jurisprudence?
Okay, so for example, above all, the Yankuba Toure case, because the Yankuba Toure case arose from the TRRC, and this was in 2019, it's 2 years into our transition. And we are still going through a transition,
Yes.
and I think Gambia is a wonderful example of a transitional justice mechanism in terms of different processes to reconstruct our country. So if the Yankuba Toure challenge to the Constitution in terms of that he's had constitutional immunity, if that had succeeded, then the TRRC would not have had any essentially it would have been it wouldn't have had any impact whatsoever.
Yeah.
Well, it would have had impact in terms of telling, but in terms of criminal accountability, because what it means therefore is a lot of these people turn around and say, well, they're clothed with constitutional immunity and therefore they couldn't be prosecuted. And these are the people who are likely to be culpable because those bearing the greatest responsibility. But the Yankuba Toure intervention, and that was amicus curiae. So what that also means is that for specific organizations, children's organizations, women's groups, and the others, you can look at a particular issue, it is before the court, and sometimes you believe that because maybe that particular issue before the court is very nuanced, it's very under-researched, or perhaps that a particular CSO organization may have a better understanding than actually the courts. And therefore, you may instruct counsel, give that particular counsel all the information that they require, intervene as a friend of the court to assist the court in arriving at the destination, the conclusion that is just and fair. So in the Yankuba Toure case, for example, which I was involved in, and Nene Cham, the current president of the bar, Saliu Tal, the former president, and Gay Sow. And we provided the court over 5,000 documents in relation to cases from Latin America, Europe, all over the world, and in Africa here. And in the Supreme Court judgment, I think 95% of the judgment was actually based on our submissions. So it now shows you that because of our intervention, like I'm telling you here, 95% or more actually was because of, so it shows you the importance of public interest litigation, strategic litigation. So in relation, but at the same time, but also tells you that, but for some of the areas that are, particularly the Yankuba Toure case, because that falls on international law, it's not something that probably our courts are deal with on a daily basis. So therefore, there may be a certain, and understandably so, of a certain understanding to a certain pedigree. So therefore, an outsider may come to assist the court to further understand that issue. So away from that, I'll give you another example. The attestations case before the 2021 election, where for the last 20 years or 30 years, the mayor of Banjul had always issued attestations because Banjul doesn't have an alcalo or a SEFO. Banjul doesn't have a SEFO, and therefore it is assumed that by default, the mayor is the SEFO.
Yeah, she
assumes that role by default and can issue. But the intervention in that court had significant, not in terms but for democracy, but also rule of law. That when citizens are concerned about some of these rule of law issues, you can approach the courts. And when you approach the courts, whatever happens, it's not all the time that it would go in your favor, but at least you would have raised awareness. 2 or 3 years ago, the National Assembly gave themselves, $54.4 million dollars loan. There was also public interest litigation in that, amongst other countries who were defending different parties. But the Supreme Court agreed with that, and that 54.4 was actually removed from the budget. And there's been other cases as well. But to come back to your question, I think about so many issues, particularly when I think about women and children, especially when it comes to medical negligence and some of those things as well, because I don't think our jurisprudence is as sophisticated as you would find in America or the UK. Yeah. So therefore, sometimes our courts naturally may err on the side of caution. They may be careful to make sure that they do not open floodgates. But the more we do these things, the more we also increase the knowledge, the understanding, and the capacity and the expertise of our courts.
And what does that mean, opening floodgates, to those who don't?
So opening floodgates, they will be thinking, this is an incident that happened maybe in Farafenye or in Bansang or in Fatoro, where a woman went to hospital, and there was some, negligence on the part of a nurse or a doctor, and the person subsequently died. The floodgates would be, they'll be worried. On one hand, they were looking at applying the law, but in some of these things, it's about weighing the facts, essentially. But so opening the floodgate, they may also be worried that, if we say that on this particular occasion, that this nurse has been negligent, blah, 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 and we are awarding, 25 million damages for the death and the suffering and other things as well, that you may now invite lawyers and other individuals or civil society to bring more and more of these cases. So they now be worried that you may now open this box that you may not be able to control.
Yeah.
But whether people bring civil litigation, public strategic litigation or public interest, actually, I think sometimes the courts ought to even encourage these things to happen, because when it happens, it simply allows our courts to interpret and enforce the law. Essentially, I'm sure, even the courts, they're part of society. I'm sure they are also outraged sometimes by certain stuff, but they cannot bring these cases themselves. But I'm sure they would be happy sometimes when these cases are brought by independent organizations, by counsel on behalf of independent organizations, so they can adjudicate on this matter. Because some of these matters, like I said, the outcomes affect society as a whole. But I would encourage for civil society organizations, independent organizations to really think about doing this more. So the opportunity would be, since the Supreme Court has given, and a couple of other cases as well, and the High Court, that sets a precedent that for the right cases and the right times, the courts are willing to move away from perhaps their previous traditional role to make judgments that have serious consequences for society, but basically decisions that actually positively change society. So I think it ought to be, we need to do it more and more.
Yes, I would completely agree, because as you've said in your response, strategic litigation can be used to effect change. And we see in a lot of countries where there's an advanced, there's a lot of experience in conducting strategic litigation. It is a strategy that's used to effect positive social change, right? It is used to change laws. It is used to change policies, as you've said. And in the Gambia, that hasn't, we're beginning to see a lot more of it now, and hopefully we'll be seeing a lot of it in the future. And in my research, while I was preparing for this, I came across this critique of strategic litigation, that it is in fact not any special form of litigation. It is just like, because all litigation is strategic. Basically, you have to have a strategy to go to court if you were suing someone for trespass, etc. What is your view of criticism such as that?
I can understand, because for any case, you have to have a strategy and a case. But I disagree with that, and I entirely disagree. Even though I can understand where that argument may come from, I disagree because the concept of strategic litigation, see, when an individual goes to court, when I sue somebody to recover land or a vehicle or $1 million, whatever happens, apart from the jurisprudence, that doesn't have any broader effect on society. So that's just an individual winning or losing a case. And for the most time, nobody even knows about it. Public interest or strategic litigation is where there is a deliberate strategy to achieve a common, broader societal objective. Whether you succeed in that through court or other mechanisms, other non-court processes, sometimes the process itself would have achieved the objective that you were seeking. So let me give you an example. If I see, it is not common in this country that we sue bodies and institutions for medical negligence. So, for example, if a woman during labor or anything like that, it may not even be death. It can be a life-changing harm, injury, because of some negligence. So if the idea now is, for example, this is because there is a law that says at any given point there must be a so-and-so quota of blood bank or blood reserve, something. I'm giving an example. That may not be necessarily, because it's difficult to legislate some of these things.
Yes.
But if that were the case and that hadn't been followed, and you now go onto the Edward Francis Small Teaching Hospital, you sue the Minister for Health and the Attorney General and whoever else is maybe culpable, that would be unprecedented. Especially if you have an organization that is supporting this individual. because for the most part they cannot afford it. So they would need assistance, not in time, but mobilization to approach the right individual who may be able to take on the case. When you do that now, and the papers start talking about it, and you approaching this from on behalf of that individual, but the purpose would be, and I'm guessing in the pleadings will show, that although the harm is suffered by one individual, that this is a system and this is a practice, and what you're trying to do is to challenge the existence of that very process.
Yes.
That is important. That has broader. So if you win there, then the thing will be that in any public hospital, there should not be any less than so and so of blood. I don't think you can compare that to an individual case which has no bearing. So the argument that public interest litigation or social litigation is unlike any other. I will decree that it is vastly different, and where properly exploited, it can really advance greater positive societal change.
Yeah, I do agree with that point. So that also brings me to my next question. I've noticed that in your responses, I've heard quite a bit about organizations, civil society organizations using strategic litigation for positive change. But in our context in the Gambia, we know that CSOs have very limited capacity to implement their activism activities, talk less of going to court to prosecute some of these issues. So what role do you think that, us as lawyers or the private bar can play in assisting civil society to take up some of these issues and make positive social change in the Gambia?
The former president of the bar, Salud Hal, and I have had this discussion that perhaps the bar ought to have, we have the Human Rights Committee, that perhaps we also should have a public interest litigation committee. So for the right deserving cases, that even without instructions, that the bar itself may intervene, either as amicus or, but like in the AKI case, FLAG intervened.
Yes.
And I'm hearing, I cannot, you know this more than I do in terms of the settlement issue. But for example, that matter going to court, so perhaps that should. But what I would also encourage civil society organizations is to try and probably approach the bar, probably have an MOU with the bar, and some of the grants coming to the bar in terms of their access to justice, rule of law projects and initiatives, to the American Bar Association or Democracy International and the others, or British High Commission, or the USAID. So probably this conversation can be expanded beyond this room.
Yes.
So where CSOs are they're capacitized, so that they really understand, because sometimes the law and the legal process and the court process, even it's a complicated matter, even for lawyers, never mind non-lawyers. So we have to debunk that. We have to break those barriers. We have to allow people to, or facilitate, create the environment for people to access justice. It's about strengthening the rule of law. So I think civil society organizations, particularly through the bar, because to do it on an individual basis may not be sustainable. But through the bar, then you have lawyers who will sign up that for a particular part of the continuous career development, CPD, continuing professional development. So lawyers will dedicate, like they do pro bono work, dedicate a certain time. Some of them may not be pro bono, some of them people have to pay, understandably so. But where you have especially bar members with interest in human rights, in transitional justice, in women's rights, in children's, and other matters that affect our society. So they can take on these matters on behalf of civil society organizations. There is a lot that is happening. I'm actually involved, I'm not going to say it now, but I'm actually involved in one now.
Okay.
That is going to be significantly massive if that matter goes to court. And it affects everybody. It affects you. It will affect everybody, almost everybody in the Gambia.
Yeah.
Particularly those who travel. I'm guessing people understand where I'm coming from.
I think I would support that one.
So there's a lot. There's a lot, because so for civil society organization and the bar this will also encourage the bar. Part of its law and society obligations and responsibilities,
Yes.
where we come together. So when there is a deserving case, then certain people will jump up and intervene, just like did in the AKI case.
Case, yeah.
So I think that needs to be looked at. I think that should be exploited, so that you have a sustainable system where there would be a continuous, strategic public interest litigation in court for cases and areas that really on issues that deserve court's intervention.
Thank you. And finally, aside from the civil society bar collaboration, are there any other steps or any other, basically any other steps that you think we can take as a country, but also on the side of the government, the legal sector, what we can do to make strategic litigation a more common occurrence in our judicial process? Because it is definitely needed. We have a lot of things that need to be changed that personally I think can only be changed through the courts. Yeah. So any other opportunities that can be used or that can be leveraged to improve the status quo with regards to strategic litigation in the Gambia?
Advocacy. Advocacy is a norm. Advocacy, in terms of CSOs engaging in public advocacy. Sometimes that may even, because sometimes I also talk to individuals who sometimes want to embark on court. You look at an issue, look at our jurisprudence, look at our courts, look at the politics at that particular time, and advise that it may not be a right time to take on some of those cases, because even though you may have the law and the facts on your case, on your side, but because of the over secondary considerations, it may not be a particularly good idea. But advocacy, social media advocacy, radio, television, other things, writing, other things. So sometimes for some of these issues, that advocacy part, especially where it is sustained, I think sometimes also hits the nail on the head. It achieves that objective. Whether there is any immediate change or not, the authorities responsible would take note. And in the long term, it makes the work in terms of engagement, lobbying, other times at the right time. It makes it easier because you would have already laid the foundation. So because we also have to understand that strategic or public interest is not always going to court. There are known court contentious, methods and ways that you can use and exploit would have similar impact. Okay. Because if there is an outcry, especially when certain organizations come together to make certain condemnations and speak with one voice and with one unity in purpose and direction and message, I think that is another way where that fails or where that hasn't achieved the desired effect at that particular time. Then perhaps we can then explore. But litigation should not always. In some cases, it may be the last resort. Actually, engagement with the right authorities sometimes, and where this may be more legal based. So maybe the Attorney General's office or the Ministry of Justice, engaging them, working with them, creating awareness even within their ministry. Because sometimes for some of these, like SDBV, these are areas sometimes where it is the lack of knowledge and capacity that impedes our work. We make certain decisions sometimes. They're not deliberately intentional, but it's just because of certain stuff. So maybe certain engagements may result in them passing a certain legislation or making a certain amendment. But another area I would encourage would be when it comes to women's rights, or women in terms of inheritance, when it comes to women in land, because in traditional Gambia, in our local traditional settings, a woman that's been married for 30 years or 20 years, the husband dies, and the house that she was occupying with the husband, the family come and kick her out. Yeah. that kind of stuff. And because of what happens here, we normally just accept. They go to the chief on the car, be like, well, a woman cannot, the family has the right. So I think those are some of the areas where it may be useful to. I know Nene Cham has done a lot of work, the president, on some of these things, but the more you did, especially where you are now targeting to send a message and succeed, and there is judicial pronouncement at the highest courts,
Yes.
I think can be very, very useful. So that is another area that perhaps organizations may look at as well.
So yes, strategic litigation is important, but there are other ways that we can get
Absolutely.
the same change, such as advocacy.
Yeah.
Thank you so much for sparing the time to speak with us today, Mr. Fati. This is greatly appreciated, and it has been a very interesting discussion. I've learned a lot about strategic litigation, especially in the Gambian context, and we're very appreciative of you giving us the time to speak with us today.
No problem at all. Thank you so much.
And thank you for tuning in. This is the Law Hub podcast, brought to you by Law Hub Gambia with support from USAID, American Bar Association Rule of Law Initiative, produced by Right Click, and we look forward to seeing you next time. You can follow the podcast on our social media platforms on Facebook, Twitter, now X, Instagram, and on YouTube at Law Hub Gambia. Thank you, and see you next time.